Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, joined here by criminal defense attorney Phillip Hamilton. He's back with us as we are going to be live in multiple courtrooms across the country today. Bunch of things to talk about, a lot to analyze. Thanks for joining us. Let's get started. Jones was initially arrested and charged with drug possession for the spice found in his vehicle. One of the drug's active ingredients is a chemical called ibipanaca. The question that the defense is asking: could this substance have intensified the defendant's alleged schizophrenic symptoms? Let's find out.
If someone has an underlying psychotic illness, what can ibipanaca do to them?
It will make it very much worse. You might think of, say, an acrobat walking on a high wire. This would be maybe the psychotic in some state of balance, going to work, living a life with very unusual thoughts. If the drug then pushes them off the high wire, their underlying illness in this metaphor is made vastly worse. And that exacerbation continues after the drug has left the system. The exacerbation is not simply a matter of intoxication on top of an illness. The illness is made worse by the intoxication. The underlying mental illness is made worse.
Phillip, I guess I'm a bit confused here. Where are we with this insanity case? Because the way I understand it is you never want to mix drugs into an insanity discussion, because if someone actively takes drugs, how on earth could you argue insanity? But they're saying it might intensify the symptoms and that these are underlying symptoms. I guess I'm a bit confused. Where are we?
I mean, I take the doctor's word on that, but in terms of where we are, as a defense attorney, here's an issue I would be a little bit worried about. You saw the police officer testifying to, Jones kind of lying about the, having used the drugs and saying that it was potpourri, or that to me is worrisome when I'm going for an insanity defense, because it's showing that he has the ability and the wherewithal to lie, to know that potentially if he tells the truth that would be wrong, right? And so when I'm trying to move forward with a defense wherein I'm saying that he acted because he didn't know that what he was doing was wrong, these are the kind of telltale signs that chip away at my defense theory. And in terms of where we are, that's where I kind of have a problem, a little bit nervous.
Yeah, that's a big question. I think we all have. Now, Jones' defense team has called a number of doctors to testify to the defendant's alleged mental illness. But yesterday, one of their own medical witnesses testified on the stand that Jones could have known, despite his mental illness, that murdering his children was wrong. Watch. Okay, let's talk about this. Phillip, you asked me as we're watching this, is this for the direct or the cross-examination?
Yeah.
I said direct. This is defense witness. Did this guy help their case at all? And by the way, the definition of insanity in South Carolina is you have to not be able to distinguish from right and wrong.
And what's the first thing this man said?
He would have been able to distinguish between right and wrong. What am I not getting? What am I not getting?
The same thing I'm not getting. I mean, Jesse, I've been away for a little while trying a case. I haven't been able to be here with you in the morning, so I haven't followed the case as closely as you. That's why I had to ask that question.
Sure.
Let me just be frank. There were some areas of his testimony that were helpful, but not helpful enough to outweigh the fact that he just entirely erased your defense theory with the first portion of that clip that we saw.
And then saying, well, he had a drug-induced psychosis, that's not insanity.
And what relevance does it have if at the end of the day, your own witness is saying that he could have distinguished legal and moral right from wrong at that point? So
right.
I'm not calling this guy. I might consult with him. I might use him to prepare for my cross-examination of the state's expert witnesses. But if I know that ultimately that is your opinion, how is that helpful to my case and how is that helpful to my client? It's almost ineffective.
That was really interesting how you said that, because two things. One, how you might consult him as a way when you do a mock trial, things to anticipate, but you don't call him to the stand. And that's a great point.
Or just help me, like to the extent that you do have some expertise, which, at this point I'm looking at this, questionable, right? But to the extent that you do have it, help me kind of have the knowledge that you have so that when I'm cross-examining the state's witness, I'm substantively asking the right questions. But I'm not actually going to put you on the stand and basically, send my client to prison. we don't need you for that. We already have a tough
Yeah.
enough case as it is.
Yeah, so there's something going on unless we just don't see what the strategy is. We never want to say ineffective assistance, but we do want to
I guess
understand
we'll give them the benefit of the doubt.
Yeah, we have to see which way they're going to go today. As we watch this testimony, we can't forget that the defendant wasn't diagnosed until after his arrest. So we look at this medication he was on. It's not like he knew what his, if he was schizophrenic beforehand and that he was taking this medication, and on the day that he allegedly killed his kids, he didn't take the medication. That would be very different than what we have here.
Right. I mean, what we have here actually relevantly plays into the overall defense theory, right? And to the extent that we don't have that witness who we just saw before her, testify that, at the time he knew the difference between legal right, legal wrong, moral right, moral wrong. This is fantastic testimony, because what it's showing is there was an underlying mental health issue that he wasn't aware of, that he couldn't take care of, that he couldn't treat, and that it ultimately kind of led to the events that played in, unfortunately, with his kids. And like, since he's been treated, there's been no further issues. He's been great. That's highly relevant, and that, even in a case like this, could prove to be convincing. I'm still just having problems again with the last witness they put on.
The last witness is still questionable. We're going to have an opportunity to talk about him. But so far what the defense has done is said, well, look, he suffered from schizophrenia. He had a traumatic brain injury from a car accident. He wasn't faking the symptoms. We've seen these witnesses talk about this. Let's go back live and we'll learn more about what she's saying specifically. All right, Phillip, this is a strong witness to at least show that he has a mental illness, and there were things going on, but that's just one part of the insanity test, right? And under South Carolina law, the main thing they have to show is he didn't know the difference between right and wrong. South Carolina is weird because the jury has an option here and say, well, if he did know right from wrong, we could still find him guilty, but mentally ill if he couldn't conform his behavior to the law. Where are we right now in this?
Well, I don't think, as the defense attorney, I want to be on the latter end, right? I don't want to be on the, guilty but mentally ill, right?
Right.
I don't want to be there. You and I did our cursory research on what that means. And basically, even to the extent that the jury finds guilty but mentally ill, it's not like Mr. Jones is going to a hospital. He still ultimately could face the ultimate penalty, death.
Right.
And so, as an attorney, what does that give me? I think probably when the South Carolina legislature wrote that into their criminal procedure law, it was basically like a hedge or like a compromise for those kinds of cases where you're dealing with jurors that are like, wait, but he definitely has a mental health issue, maybe he is insane. It was a way that they could still ultimately get the conviction, have those jurors feel good that, look, he's going to get the proper treatment in prison. But as a defense attorney, how does that help my client if he's getting that kind of treatment right before he dies?
He may get some benefits or advantages or certain, special treatment in prison, but he could be sentenced the exact same way, like you said, to the death penalty. And this is a big case on a lot at stake. We're going to take a break. When we come back, we're going to jump live. Stay tuned.